Thank you very much, Mr. Chairman. A key point of conversation has been the Impoundment Control Act. And back when Nixon decided to start impounding funds, two things happened. One is there were appeals to the courts, which eventually made it to the Supreme Court. And the Supreme Court reinforced that, in a separation of powers embodied in our Constitution, Congress makes the law, the executive has to follow the law. And that means to spend the money in the way that Congress has laid out. The second thing is that Congress said, but you know what? We should create a fast track for a president to undo or propose undoing spending that the president considers inappropriate, called a rescission. That rescission power was used in the early years after the 1974 Budget and Impoundment Control Act, but not used much since. And you have a law degree. You practice law, correct?
That's correct.
You have a fundamental education in the understanding of the U.S. Constitution, do you not?
I do.
Do you understand the importance of law being applied as written?
Certainly.
And so how do you feel about this situation in which funds are being impounded currently, which the Supreme Court has said is unconstitutional?
President Trump ran on impoundment. I've heard Director Vogt in his hearings speak about impoundment. I've studied the issue, but I am seeking to be confirmed to a position that is not a lawyer position. I won't be making the legal determinations for OMB or for the administration in terms of the legal positions that it decides to take. I am persuaded, though, that there was history in the United States before the 1974 Impoundment Control Act. Former Senator Harry Truman, as President of the United States, impounded funds to prevent the funding of a squadron of strategic aircraft. Ulysses S. Grant exercised impoundment power. Thomas Jefferson exercised impoundment power. I think, Senator, when you dig in, it's a compelling argument that there is power in the executive in the nature of impoundment. Exactly what its contours are, I don't know. I won't be deciding those things, but I support the president's plan to use impoundment to get federal government spending in line.
Well, sitting behind you is your future boss, who very much advocates that he doesn't care what the Supreme Court decided before because he disagrees, and he thinks the president disagrees. He was very honest and upfront about that. But in our system of government, we don't get to decide the constitutional issue and say individually we disagree with the Supreme Court. Now, if the Supreme Court now relitigates this and comes to a different conclusion, then there would be the additional powers granted by the court. And I understand that that's the plan. But at this point, every consideration has been that this is illegal and unconstitutional. And I'm sorry to hear that with your training in the law, you're inclined to simply say, well, President ran on it. He didn't give a lot of speeches about impoundment, by the way. And he didn't give a lot of speeches about the plan to cut $2 trillion from fundamental programs for families to give $2 trillion in tax giveaways to the richest Americans. And he didn't talk about it last night either. But when there's a fundamental question of law, and you as a trained lawyer say, well, I'll just follow whatever the president says, that concerns me. Because we need to have people of integrity who are willing to follow the law in key positions like this. Are you going to be a person with integrity to follow the law?
Senator, you've put words in my mouth that I did not say, and you've put words in Director Vogt's mouth that he did not say with respect. And I certainly am a person of integrity, but it is not a question of not following the Supreme Court. For example, you say the Supreme Court has decided the constitutional questions of the Impoundment Control Act. That's just misinformed.
Oh, really?
No,
well, why don't you inform us all on how given that they made that decision?
Well, they didn't, sir. Train versus New York, it does not consider the Impoundment Control Act, and it does not consider the president's power of impoundment. Neither one.
Well, we'll continue that conversation because others disagree with you. I'm not a lawyer myself, so I'll take this under advisement. But that's certainly my understanding from other legal scholars that this has been well adjudicated. I am concerned also about your flip-flopping. You proceeded to say in a letter back in 2021 when you were concerned about whether or not President Biden was proceeding to not execute the law exactly as written. You said this action is an abuse of the executive branch's authorities and appears in violation of the Impoundment Control Act of 1974. Here you are, a champion of the Impoundment Control Act back in 2021, and now you're saying you're not so sure, you just want to follow the president, and the president doesn't believe that he needs to follow it. I'm a little concerned about that flip-flopping. Can you explain why your opinion has changed so dramatically in just a couple of years?
Well, first, it hasn't changed that dramatically. In that instance, what was being discussed was President Biden's 3-year, by then, refusal to spend money that the Congress had appropriated for border wall construction. GSA had earlier said at an earlier point that his suspending funding for a programmatic review was not in violation of the Impoundment Control Act, by the way. And so it's something that had continued almost in the entire administration at that point in time. And furthermore, as I said, Senator, I've spent time studying Train versus New York that you made reference to. I've spent time studying the history of impoundment, and the presidents who've used it, and the circumstances, and I'm disinclined to believe that the Congress could fundamentally alter the balance of authority between the executive and the Congress when they decided to pass a statute in 1974.
My time is up, but I'll just say you were very firm in attacking President Biden for impoundment. Now you're very firm in granting license to impoundment. That seems like a massive flip-flop to me.